He walked into that courtroom believing the truth would be enough. He had the emails, he had the timestamps. He had witnesses who would confirm everything. What he didn't have was a lawyer. And what he didn't understand, what most people never understand until it's too late, is that courtrooms don't reward honesty, they reward procedure. His name was Marcus Webb, 37 years old, quality assurance manager at a mid-sized logistics company, no criminal record, no history of lawsuits, the kind of person who reads instruction manuals and follows traffic laws even when no one's watching. The kind of person who thinks systems work if you just play by the rules. This story isn't about guilt or innocence. It's about something more unsettling. It's about what happens when an ordinary person makes a decision that seems completely rational and discovers too late that rationality and the legal system don't speak the same language. Before we go further, I need you to do something. Subscribe to this channel if stories like this matter to you, and leave a comment with the country you're watching from. Because what happened to Marcus isn't unique to one place. These patterns exist everywhere, and understanding them might be the only protection you have. Marcus lived in a town of 40,000 people, the kind of place where you recognize faces at the grocery store, but don't necessarily know names. He'd been at his job for 11 years, steady promotions, performance reviews that used words like reliable and detail-oriented. He had a mortgage, a 10-year-old car, a daughter who played soccer. Nothing about his life suggested he would end up in court. The problem started with a contract dispute. Marcus had hired a general contractor to renovate his basement. Standard job, framing, electrical, drywall. The contractor quoted $12,000. Marcus paid half up front, which is normal. The contractor started the work in March. By May, the work had stopped. The contractor kept rescheduling. First, it was supply chain issues, then a family emergency, then another client whose project ran long. Marcus was patient. He understood that construction delays happen. He sent polite follow-up texts. He offered flexibility on scheduling. What Marcus didn't know was that the contractor had taken deposits from 4 other clients that same month. What Marcus didn't know was that the contractor's business license had lapsed. What Marcus didn't know was that patience, in legal terms, can become something else entirely. By August, Marcus stopped being patient. He sent a certified letter requesting either completion of the work or a refund of the $6,000 deposit. The contractor didn't respond. Marcus sent another letter, then another. Each one documented, each one reasonable. In September, Marcus filed a claim in small claims court. The amount was within the threshold. He didn't need a lawyer for small claims. That's the entire point of small claims court. It's designed for ordinary people to resolve disputes without spending thousands on legal representation. He filled out the forms carefully. He attached copies of the contract. He attached copies of the payment receipts. He attached the correspondence. Everything organized with colored tabs. Everything in chronological order. He felt prepared. What he didn't feel was worried. The hearing was scheduled for November 14th. Marcus arrived 20 minutes early. He wore a suit. He brought 3 copies of his evidence binder, one for himself, one for the judge, one for the contractor. He watched other cases before his. Simple disputes, broken leases, unpaid invoices. Most took less than 15 minutes. When his case was called, Marcus approached the plaintiff's table. The contractor didn't appear. The judge noted the absence. This seemed like good news. Marcus assumed it meant he would win by default. The judge asked Marcus to present his case. Marcus began explaining. He referenced the contract. He showed the payment records. He explained the timeline. He was factual. He was organized. He was convincing. And then the judge stopped him. "Mr. Webb, did you send a demand letter to the defendant before filing this claim?" Marcus confirmed that he had. He showed the certified mail receipts. "And how long did you wait after sending the demand letter before filing this claim?" Marcus checked his records. 11 days. The judge's expression didn't change. The statute requires a 30-day waiting period after a formal demand letter before a claim can be filed in this court. Your claim was filed prematurely. Marcus felt something shift. Not panic, not yet, just confusion. "I can wait," he said. "I can refile." "You can," the judge said, "but this claim is dismissed without prejudice. You'll need to start the process over. Without prejudice. That phrase sounds harmless. It sounds like a technicality. What it actually means is that your case is erased. The clock resets. You start from zero. Marcus drove home trying to understand what had happened. He'd followed the rules. He'd done everything right. He just missed one procedural requirement buried in the statute. One timing rule that wasn't mentioned in the small claims court information packet. One detail that seemed like it shouldn't matter. He went home and researched. He found the statute. Section 52, subsection D, paragraph 3, 30 days. He'd known about sending a demand letter. He just hadn't known about the waiting period. And now it was October. If he sent a new demand letter today and waited the full 30 days, he couldn't refile until late November, which meant he probably wouldn't get a hearing until January or February. 4 more months. Marcus sent the new demand letter. He waited exactly 32 days this time. He refiled in December. The new hearing was scheduled for February 9th. He prepared the same way. Same evidence. Same organization. Same suit. This time the contractor appeared. He didn't have a lawyer either. He had a folder. Not organized. No tabs, just papers. He looked exactly like Marcus expected. Tired, defensive, irritated. The judge asked Marcus to present his case again. Marcus did. Same facts, same evidence. He felt confident. The contractor hadn't even finished the work. The contractor had stopped responding. The evidence was clear. Then the contractor spoke. He claimed that Marcus had changed the scope of work midway through the project. He claimed Marcus had requested additional electrical outlets that weren't in the original contract. He claimed that Marcus had delayed the project by not being available for inspections. None of it was true, but he said it calmly. He said it with the same factual tone Marcus had used. Marcus tried to respond. He explained that he had never requested additional work. He showed the original contract. He showed the email correspondence, everything documented. The judge looked at both sets of evidence. Then he asked a question that made Marcus's stomach drop. "Mr. Webb, do you have a written change order showing that no additional work was requested?" Marcus didn't have that, because you don't create paperwork to prove something didn't happen. You don't document the absence of a conversation. That's not how normal people think. But in court, the burden of proof isn't about truth. It's about documentation. The contractor claimed he had incurred additional costs because of Marcus's changes. He didn't have receipts. He didn't have invoices. He just had his word. And because Marcus couldn't prove the changes hadn't been requested, the judge was left with two conflicting stories. In civil court, when the evidence is ambiguous, the plaintiff has to prove their case. Not beyond reasonable doubt, that's criminal court, but by a preponderance of evidence. More likely than not, the judge ruled that Marcus had not met that burden. The claim was dismissed, with prejudice, which means it was over. Marcus walked out having lost $6,000 and 7 months of his life. But this is where the story actually begins, because what Marcus did next is what this story is really about. He decided to appeal anyway. Small claims decisions aren't supposed to be appealable. That's part of the design. But Marcus found an exception. If there was a procedural error, or if the judge made a legal mistake, you could file an appeal in the county circuit court. It would cost $500 to file. And if he appealed, the contractor could hire a lawyer. Every lawyer Marcus consulted told him the same thing. Don't do this yourself. Marcus did it anyway. He filed the appeal in March. The contractor hired a lawyer. The attorney filed a motion to dismiss the appeal. Marcus had 20 days to respond. He filed on day 21. The court didn't read his response. The appeal was dismissed. Then came the counterclaim. Malicious prosecution, $3,200, and 14 months after the dispute began, Marcus stood in court again, this time defending himself from being punished for trying to use the system at all. The judge ruled the appeal had been frivolous. Total damages, $4,100. Marcus had now lost $10,600 for a basement renovation that never happened. Here's what matters. Marcus wasn't dishonest. He wasn't reckless. He wasn't malicious. He was uninformed. And the system punished him for it, not with cruelty, with procedure. The legal system isn't designed to produce justice. It's designed to produce finality. And when truth and procedure conflict, procedure wins. Every time. Marcus eventually paid. He moved on. He finished the basement himself. But he learned something most people learn too late. Being right isn't enough. Knowing the rules you're told about doesn't protect you from the rules you aren't. And self-representation isn't freedom, it's a trap. The question isn't whether the system is fair. The question is whether you understand how it actually works before you need it. Most people don't. Don't be most people. If this story made you learn something, share it with someone who needs to see it. Do not forget to subscribe to our channel for more insightful videos like this.